We welcome you to today's webinar. It's a SACNASP accredited webinar on unlocking innovation through intellectual property. My name is Matshidiso Matabane. I'm the Science Communications Manager here at SACNASP, and it is indeed my pleasure to serve as your host and facilitator for today's session. Thank you very much for joining us this morning in support of your ongoing commitment and support to excellence and professional development in the natural sciences. Today's workshop is presented in partnership with the National Intellectual Property Management Office, which is NIPMO. It is a unit of the Department of Science, Technology and Innovation. NIPMO plays an essential role in strengthening South Africa's national innovation system by ensuring intellectual property generated from publicly funded research is properly protected, managed, commercialized for public benefit. The theme for the session this morning, again, is unlocking innovation through intellectual property. And this speaks directly to the intersection of science, technology, and strategic thinking. And as natural scientists and researchers in our spaces, we are constantly generating innovative ideas, methods, and solutions. But without the correct understanding and application of IP frameworks, much of this innovation remains vulnerable, underutilized, and lost to a certain extent. In this webinar, our distinguished guest from NIPMO will guide us through the key principles of intellectual property, explore how IP relates to the work that we're doing, and also outline some of the practical steps for safeguarding intellectual outputs, whether you work in academia, government, you're a consultant, or working in industry. Again, the session is accredited or rather validated by SACNASP, and you qualify for 0.3 CPD points, and certificates of attendance will be issued in the next 2 days. Just before we proceed, just a few housekeeping notes. We encourage you to use the Q&A box or segment to pose your questions and any comments that you may have. And just to also highlight that the session is being recorded and will be made available on our website for future reference. Now, it is my pleasure to introduce my colleague from NIPMO, Ms. Ntangenezeni Moanalo, who brings extensive experience at the intersection of IP, policy, and innovation strategy. Just a brief profile about our guest, Ms. Moanalo. She holds a master's degree in wine biotechnology from University of Stellenbosch, and she also has an LLB degree from UNISA. She also has an advanced diploma in business project management from UCT. She is an admitted attorney of the High Court of South Africa and has been in the National Systems of Innovation space for over 16 years. She has worked for various organizations, for the Innovation Fund, for the Technology Innovation Agency, or rather TIA. She worked for the Department of Science, Technology and Innovation. She also worked at UNISA under the Directorate of Innovation, Technology Transfer and Commercialization. And she is currently the Director at NIPMO for Regulatory and Compliance. And we welcome you, ma'am. Over to you.
Thank you very much, Matshidiso. As has been introduced, I will then put off my video so that I save on the bandwidth, and I will then start my presentation. I think just to put things in perspective, I know Matshidiso did a bit of introduction. You can see my slides, right, Matshidiso?
Yes, we can. Can I proceed?
Okay, so I come from program 2 within the Department of Science and Innovation. It's our program is called Technology Innovation, and we are a chief directorate within Technology Innovation Program 2, called the National Intellectual Property Management Office. So that's how we link to the DSTI. I will start my presentation by just talking broadly about what an innovation ecosystem is. We will then touch base on really introduction on various form of intellectual property. We'll touch briefly on the IP policy. We'll then touch on what the National Intellectual Property Management Office does, which is the NIPMO. So, in essence, the innovation ecosystem really it's a whole cycle of knowledge creation. Um, Normally, as you're aware, as scientists, that all this knowledge that we're creating is it actually starts as an idea that someone come up with. Once you have identified an idea that you need to work on, then you can then protect the idea, and one can then develop the idea further into a product or into a service that they want to put out there in the market. And one can then also look at the various partners that they want to collaborate with in order to put the product or the services into the market. There's various ways on how one wants to put those products or services out there. One can opt to give license to interested party or to sell their intellectual property. We'll touch base on it a bit later. In order to implement their product or service into the market. So it's a whole cycle that starts with just an idea that get then realized into something that is tangible that can then be put into the market. I've already spoke to that slide. So what really is intellectual property? Intellectual property really is the creation of the mind. It's all these creative ideas that we actually come up with. It depends on which particular one is looking at. There are the legal statutory one, which are your intellectual property rights that are conferred from the various intellectual property that one may come up with. If you come up with the new invention, you can then protect that through a patent. If it's work that has to talk to symbols, logos, and names, that can be protected through the trademarks. If it's the works that we normally refer to as the works, which encompasses your computer programs, the database, literary and artistic works, your cinematography, that can be protected by what we refer to as copyright. If it's new plant varieties that one come up with, those who are in the agriculture space will understand this better, then that can be protected by plant breeders' rights. Or if it's a design registration, that can be protected by a registered design. You will understand that the various forms that I'm going to talk to are normally based on South African laws, even though sometimes I would also include what others are doing elsewhere. The most important thing that one need to realize and always think about is that when they need to have the various form of intellectual property, for you to get protection in a particular country, you need to file in that particular country. So it's territorial. So that's very key. So if I want IP protection in South Africa, I need to file in South Africa. US or Europe, you need to file in those particular country. Having protection in one country doesn't give you rights in other countries. They are in South Africa, the ones that are listed here are the ones that are regulated by the legislation. So that means there's an act that actually talks to what you can protect, for how long, what cannot be included, etc., etc. But there are other two that we'll talk about, which is confidential information and trade secret, but those doesn't have the law that regulate them. So I know that we haven't spoken about the various form of intellectual property, but the next 2 or 3 slides just want to highlight that in one company, you can have various form of intellectual property that is applicable to that particular company. So here we just took a easy example that everyone will be able to relate to, which is a barber shop company. So just looking at that barber shop and the picture that you're seeing, you will see by the third slide that there's actually various form of intellectual property that I referred to the previous slide that actually can be included in just this picture. So, for example, our first one, which is highlighted here, is the patents. So that particular chair was actually protected by a patent. So how it works, how it functions, is protected by a patent. The next one that we're going to talk to here in this particular picture is the design registration. The chair that is coming from from the drawer, that chair have got a functional design protected over it. You can comb and still cut with a small scissor. I'm sure you've seen at the barber shop when they cut the edges. So that is protected by a registered design. The third one, that was the first one on the slide, is actually the trademark. So that's how that barber shop trade. So you're able to actually distinguish it amongst other barber shops. But what I've shown on that drawer is that there are a lot of things that are placed there. So all your conditioner, the shampoo, all those are the trademarks that you see on the screen of the various company. The lotion that might be using after doing the haircut, the soap that they might be using, the Dove. So in that just shop, you might find other trademarks over and above what the barbershop trademark is. In that drawer that is highlighted, you actually might get what we refer to as the plant breeder's rights. You know, maybe a barber came with an orange to eat over lunch, which is not the most hygienic thing, right? There might be an avocado there that he has put to take out and then use on his bread during lunch. The fourth one is the copyright. So all those booklets, what is contained in there is protected by copyright. So the electronic scissor will come with how to use. I'm sure you have seen in a lot of products that you get the leaflet about the product, how the product works, what you can do, what you cannot do. All those leaflets are actually protected by copyright, the information that is in there. So this is just to demonstrate that in just one shop or just that one room, you might find various forms of intellectual property, which this is just testament that even as an organization, you might have more than one protection of your intellectual property on one product. So we actually gonna then continue and touch base on each and every form of intellectual property, just the introduction. So we will start with the first one. So in this instance, we'll look at the copyright. In South Africa, copyright is regulated by a legislation, the Copyright Act, and however, you don't need to go and physically file for copyright at the CIPC, which is the regulator in terms of in South Africa where the IP protection are being done. You, as long as it's reduced into material form, then copyright exists. So normally all the work that is protected under copyright is referred to as the works. So that will include protection for authors, what the author have written, artistic, the music composer, the programs for their creation that they've come up with. as long as it's reduced, it's written down and reduced into material form, or it's recorded or saved, copyright exists. In various form of copyright that can be protected, you get protection that lasts very long. Normally, is the life of the author plus the 50 years after they've passed away, or where the works referred to publication is 50 years from the date of publication. So that gives a very long protection. It actually grants the owner of the rights to be able to control how their work is being reproduced, distributed as well. And I'm sure all of us are familiar, or we have at least seen the last point where it's a C, small c in a circle, which sort of demonstrates that copyright exists. It is recommended to put that in the works that you do, but doesn't mean that when you don't see that small c, copyright doesn't exist. As long as something has been written down, has been recorded or saved, copyright exists. But in practice, it's recommended that you put that C to say when was it published. So I've sort of touched base on what does copyright protect. It protects quite a variety, literary work, artistic work, sound recording, published editions, computer programs also falls within that. Also musical work, cinematograph, films, and broadcast as well. So that's just the introduction to copyright that we are going to talk about today. And the other thing I want to talk or refer to in terms of copyright is that copyright, it's one of the longest and probably one of the rights that is difficult to enforce, because people take people's books and photocopy the whole book, or take the music and duplicate it without paying into recognition what the authors have come up with. Unfortunately, in IP law, you as the originator or a person who have come up with the various forms of intellectual property, you need to be the police to see who is then infringing on the rights that has been conferred to you. That's just how it works. You need to be able to identify the people who are actually infringing on your own work. So you become the police of the intellectual property that you've come up with. The second form of intellectual property that we'll talk to today is the registered design. So this, in essence, protect the shapes and just how something looks. All the patterns that you see on the cutlery, those will be protected by what we refer to as registered design. And in South Africa, you get two forms of design. You get aesthetic, just how something looks, and you can get up to 15 years protection. And you also get a functional design that you get protection for 10 years. A typical example for a functional design registration will be a pinpoint plaque. I'm sure those who were born before 2000 will recall that you used to have a pinpoint plaque that had an extension on the side when the cell phone chargers were still very heavy and they'll trip from the charger. So that gave an anchor for a charger to stay in and hold on while you're charging your phone. Thankfully, the chargers are quite light currently, so you don't need that anchor, but that could be something that could be protected by functional design. Every year, once you have filed your intellectual property, you will have to pay renewal fees so that it remain in force. So if you don't pay for renewal fees, either for your design or your patents, your registration lapse. So it's no longer effective. So you have to maintain it by paying the renewal fee, with an exception of what we'll talk about on trademarks, how it works on trademarks. And there are specific requirements in each and every form of intellectual property. For a registered design, it needs to be new an original for you to be able to file for design registration. And you get rights that allow you to prevent others from making, importing, using, or disposing the same articles as you. In other countries where they do not have functional design, they will refer similar protection as utility patent. The next slide just show various examples of design, and this will also be able to link it to the next presentation on trademark, because you can see that these are the different logos, various design, but however, you can also already see that the first one, you can recognize that it's an Audi. So that's how Audi also trade. So it's their trademarks, but all those that you see in this picture, it's also the various registered design of the various car manufacturers. So you can actually be able to distinguish. It's not confusing that a Toyota is not similar to a Mercedes-Benz. So those are the various designs that one can then also have. And then a further example is that you see all white cars, but you can actually see that their design is completely different from one another. You're able to distinguish the various models, even all the cars are white. These are further examples of registered design, how your smartphone will look like, how they'll use it or apply it when they file for technical and medical instruments as well. You can file for various shapes of furnitures, for jewelry, for watches as well. So all of that will encompasses some form of registered design. I think just to make it easy, because I've already sort of linked the design with the trademark, I will then present on the trademarks, and Matshidiso, then maybe we can then see if there are any question before we can then proceed. I just felt the trademarks link well with the design as well, which I have already mentioned on the previous slide. The trademarks, this is the third form that we're discussing today. I'm sure you have seen and you know a lot of these trademarks. These are just a way in which the words and the marks we're able to distinguish the goods and services that various companies use during the course of their trade. So in the next slide, you see some typical example. You can file for just the wording, the letters, the numerical, the symbols, the 3D, and the audible sign or the oral distinguishable features. You get protection for 10 years and you need to continue to pay renewal fee. However, trademark is in perpetuity, so it doesn't expire as long as you're paying renewal fees. And I think you will understand how vital that is, because people who are in trade, they could not afford that on 10 years. I market my, for example, how I do business as KFC, for example, and then after 10 years, I'm not able to use that mark. So it's in perpetuity, subject to paying renewal fees. It also gives you rights to prevent others from using a confusingly similar mark. However, which is very, very important with trademarks, is that it doesn't prevent others from making and selling the same goods. For example, as KFC, if I have filed for a trademark as KFC, I'm in the space of food, right? Chicken in particular. I cannot monopolize that space and then not allow anyone who want to be in a chicken business. That's why you also get your Nando's and Chicken Licken. However, you can prevent someone who is coming with a brand that is confusingly similar to yours. For example, say KFG. So that is confusingly similar. So people might go to KFG thinking that they're going to KFC. So you will then be able to stop someone who's using a confusingly similar mark. So it's quite important and to note that it's not to monopolize the whole space for goods or services. However, you should be able to distinguish between two people giving the same service or product in the same space. It should not be confusingly similar. I'm sure you have seen in various items that you get a TM written on top of someone's trademark. That just means that it hasn't been registered, so it's trademarked by use. And if it's on the R and in small circle, it means it is a registered trademark. So that's the two main distinguishing factor that between a trademark and a registered trademark. So how trademark works is that it have got different classes. So you get classes for goods and you get classes for services as listed in this PowerPoint. So you need to then select, are you registering for goods or are you registering for services, for example. However, for example, if you are also having goods, for example, I want to register a car, a Toyota, for example, right? As a proper car, as a living car, if I can put it that way. You need to register in its own class compared to, and then you can then register a toy, for example, a Toyota toy car. You also then need to register it in another class for you to be able to get protection for both for toy and for a real car. So this is really much determined by classes that one can register in, and you register for all the classes that you want over and above after you have distinguished if you want trademark for services or you want trademark for goods. So this is just an example of types of trademarks, and there are those ones that we're quite familiar on that we refer to as traditional marks. So where people then either use the words to describe their trademarks or letters or a combination of letters and words. Some just only use like a picture, a shell. You'll just see a yellow and a red, then you know it's a shell without having the wording. Or you get the one that are embedded with both the wording and the actual picture. So all of that is accepted in terms of the trademarks law. You also get the non-traditional marks, wherein you protecting for your shapes, the color, particular color that your company wants to use, it's allowed to use a particular color. The font, for example, how the Coca-Cola it's written in that particular font and the way it's written. You also can actually get non-traditional marks like the moving images. And also now you're able to then, if you're able to prove that the smell of whatever goods that you have it's very different from what is out there, you're able to actually have a trademark. That's my last slide on the trademark, Matshidiso.
Thank you very much, Ms. Mianalo. We've got a few questions under the chat. And the first one is from Petro Erasmus, who asked, documentation compiled by individual environmental assessment practitioners and specialists are also considered intellectual property. What recourse is there for these practitioners that use other people's reports and submit them as their own without referencing the original author? That will be the first question. If you can perhaps tackle that one before we move to the next.
So Yeah, it was quite a long question. So, but that is will fall will follow more on the plagiarism, where someone is taking someone's work without acknowledging the work that they have done, or is it more referred to the confidential information? So I missed the first part of that particular question. If you can read it for me again.
Essentially, it says what recourse is there for people that use other people's reports and submit it as their own without referencing the original author of the work?
Yeah, I think that one can just get in touch with them and tell them that they actually have done plagiarism on your work and you are not being acknowledged. Unfortunately, it's not one of the forms of intellectual property that we're covering here today, but in the form of the intellectual property that we're covering today here, you, as the person who have come up with that particular invention or design, you get granted rights, and those rights give you the powers to stop someone who's infringing on the work that you have done. So I want to understand is the same thing with someone who's using the work and they've done plagiarism. Is to let them know that this is the work that you've come up with on this particular day. They need to stop using it. And I think everyone who's in the scientific space knows how to curb that. It's at least to acknowledge the work. That's why referencing is quite important. But if you see there's nowhere where you're being acknowledged, it's quite important to also let them know and ask them to refrain from doing such. Or then they must always reference your work.
And then there was another question from Nitesh. Based on the Copyright Act, how is it legal that an organization, for example, an employer, can assume your work or productions of your work as the intellectual property since you are just an employee? Surely, as the creator of the work, you are ultimately the owner of that work and should be required to cede your rights to the work to the employer. Can you perhaps advise on this? And I think this ties in
Okay.
with Seipe's comment as well, or rather question. Does IP belong to individuals, or is it always tied to the company or the employer?
Okay. I will try to answer this the best way I can. And I was sort of expecting this particular question. It's one of those that you know that you're gonna get. I think what we must always remember is that the employer, right, hire you for the service that you're rendering to them, and then they give you salary, right? So you doing that work in your capacity within the course and scope of your employment. Most employment contract, before I actually gonna give you reference to legislation, will already say that that will be owned by the employer, right? So that's normally according to your contract of employment. That will be owned by the employer, right? The second thing, in terms of documentation that you find that the employer have got, like the IP policy, which are internal policies that are enforced by the employer, they will have something that talks to that effect. Over and above, the various legislation as well, they will say if you're doing something within, like your Patents Act, if you're doing something within your course and scope, your employer can actually claim that work that you are doing, because you must think it in this way that you are employed 8 to 4 to render services to your employer. So that's how the employer then become the owner of the intellectual property. However, with the new development and legislation that have been put in place, for example, in South Africa, through the intellectual property rights emanating from publicly financed research and development, which is the IPR Act that I'm going to talk about later on my presentation. It gives the various universities and the Science Council the rights to own the intellectual property. However, there's also provisions that the employer need to make in terms of saying, if we're able to protect this intellectual property, or if we're able to protect and commercialize this IP and make money for the organization, how do we then share the money that we have with the people that have come up with that work? So it's not an outright that because I'm employed by the DSTI and I'm doing something within, let's say, for example, let me give you a practical example. I work for the CSIR, which most of you will be familiar with, and I'm employed as a researcher to work in the lab to come up with new innovation and method and processes of doing something quicker or better. And indeed, we work on that, and then we find something that is tangible and we protect it. I'm doing it on behalf of the employer. So the employer will own, like I've already said, now there are legislation that are also saying, once the employer own and they're making money out of it, how do then share whatever money that they're making over and above what they've been paying you as your salary of the work that you do between 8 and 4 Monday to Friday, for example. It's a different ballgame if I come up with something completely out of what I'm hired to do. Let's say I am a tea lady, and all of a sudden I'm so smart during my free time at work, at home after 4, or during the weekend, I come up with an invention of curing HIV, for example. My employer might not have a basis to actually claim that they know they own that intellectual property, because it's not for something that I'm hired to do at the CSR. I'm hired there as a tea lady, but I come up with vaccine or cure for HIV, for example. I hope that sort of answer your question. And when we talk about the IPR Act, it will give a further basis of what I'm referring to.
Okay, thank you very much. There's another question from Ulrike. What if a company is the owner of such an innovation with IP and the company deregisters or is liquidated? Then what happens to that IP in that case?
So there's a company, and the company owns the intellectual property,
Yes,
and the company doesn't exist anymore.
yes, it deregisters or liquidates.
I'm assuming that during that liquidation, remember, intellectual property is part of your asset, will have formed part of that whole process of liquidation. Because intellectual property, it is an asset in a company. You can put it in your books as an asset. So depending on the decision that they will have made during liquidation, do they want to sell that intellectual property to someone else who can further develop it? They could have taken that decision, then they'll have get money in return that will then make part of that whole liquidation process. So it depends what the company wants to do with it. And I think if it's a good intellectual property that have got prospect during liquidation, those decisions will be taken to say, is it that let's try to sell this intellectual property and see how much money we can salvage. If then part of the liquidation doesn't talk to intellectual property, which I doubt pretty much, then it means the company is no longer there. It means renewal fees are not being paid for that particular intellectual property. And it's in terms of a lot of laws across the world, then that intellectual property will lapse. So it will not be enforceable because it hasn't been maintained.
Okay. Then there's another question from Megan. Is there a way to verify if something is truly registered or if they have just put up a symbol down there? Is there a way to verify?
A symbol, where are they referring to copyright? I hear the question to say, is there a way of verifying if something is registered? You mean if one have got a particular form of intellectual property?
In one of your slides, you were explaining the TM there. So is there a way to verify that?
Yes, you can go to the CIPC, which is the office that administer this in South Africa, and go do a search and check if really that trademark exists, which most people will also do when they want to register a new company, because you can register a company with the name that already exists. So you can do the searches. A lot of people in business, obviously, you find that they use patent attorneys, which are lawyers who specialize in intellectual property law. You can also request them that they do a search for you just to check. I think it's misrepresentation that you say you've got a registered trademark, whereas you don't have it. So, but you're able to do a search and see if this trademark indeed exists.
Okay. Thank you. There's another question from Vanessa. Can a trademark only be renewed by an attorney, or can one renew it by themselves?
I know in South African law, right? I don't really specialize in trademarks. I'm gonna be upfront with you. I know more on patents than I do with trademark, because it's two area of specialization. But I know in terms of the patents, you can file your own provisional patent application, but you need a patent attorney to file your complete specification so that they're able to sign it off. So with trademarks, I am not 100% sure if you can do it yourself at the CIPC, and whether you need a trademark. But look, in South Africa, because our office at CIPC, that's why we always, or most of the time, we encourage people to do it through lawyers, because some of the searches are not electronic available. So those people with the law firms have got people based at the particular office, so they're able to also manually check for you the recording. And I know for trademarks, it's quite affordable as compared to your patents in terms of the fees that they charge. So it's always advisable to use someone who specializes in the field, because our office, it's really a formal office. So it doesn't have people to do like things like examining your patent application. So that's why when we talk about patents, I also refer to you need a patent attorney to actually do that, so that they cover your invention adequately, if I can put it that way. So for trademarks, I am not 100% sure if you can do it yourself, or you need to be done by a specialist only. But doing it with a specialist, at least you've got someone who's skilled and vested within the field, who'll be able to look at your best interest.
Thank you. And another question from Mark: is a declaration by an author of a report properly worded to claim the IP in the report sufficient protection under our laws in South Africa to avoid the clients just taking it as their own?
The declaration of the copyright doesn't. Sorry, can you just read the question for me? Because there's two things. Normally in IP, right? There's two things that you find that I've got an invention, right, which is can be protected by a patent, but then I'll then write that in an information that will be protected by a copyright law. So so doesn't necessarily mean that if I've already protect the underlying technology through a patent, that I'll always hold on as the owner, as compared to what I will have disclosed written form on a copyright. But you can read the question again for me.
Okay. Is a declaration by an author of a report sufficient protection under our laws to avoid the client just taking that work?
Yeah, that is also part of demonstrating that you are the one who came up with the work. But I'm not quite connecting to say whose take is it. Someone infringing on what you have written down. If maybe the person can just explain that.
Madeleine, if we can allow Mark Hoodhart to pose the question, please. While we're doing that, I'll just move on to the other question that was from Seipi. Why are IPs given timeframes? I think you had indicated this in one of your slides.
Okay, so the whole reason is that it's being seen. All of you know and understand that it's a monopoly, right? So what you are doing is that you're actually getting rights to protect your intellectual property, for example, for 10, 15 years, and be the only person dominating in that particular space. You can give licenses or you can assign your IP later, depending on the strategy that you want to use. You do that with the government, with the understanding that after that 20 years, it's going to become free information that everyone else can also use and benefit on. So that's the whole point. It's not applicable to trademark, because trademark is how people need to continuously run the business. So it's the understanding that if you've got a very good innovation, in that 20 years, you should have made good money, that after 20 years, you can also share the good ideas that you have come up with. So it's a monopoly in exchange of me having product and services, and I put them on the market and make money in 20 years. After that, everyone else also can just use and benefit. And this is being applied quite a lot in the pharmaceutical space. Those who are in the space, they'll understand. I'm sure you have heard when you go to the pharmacy, they will ask you if you want a generic or original medication. For example, a Panadol. There's an active ingredient, right, which is a paracetamol. So what happened is that those people will have spent money, time to do research and development to come up with that painkiller, right? Pain relief. So they're able to sell their products for that 20 years and stop everyone else who's infringing on the active ingredients that they've come up with. However, it can't be that it's for life. Then it means they're the only people who are going to make money for life. That's why you get other companies also start working on the same active ingredients. When the patent lapse in that 20 years, they'll also be able to, enter the market as well. So that's the whole point. It's an exchange of monopoly, which we understand you're going to make money for that period of time. But at some stage, you need to become available to everyone else to be able to benefit from the brilliant idea that you've come up with. Thanks.
Thank you very much. I will now allow the last question from Mark. If he can kindly come through, then we can proceed with the presentation. Mark, over to you.
Mark, you are able to unmute if you want to talk.
Oh, we can then take it at the end if Mark is still a bit far. I just wanted to make sure that, or maybe what I've said answer his question. We can always take it at the end.
He might not be in a position to talk. He is able to talk, but otherwise he can clarify in the Q&A again.
Okay, thank you very much. I think we can proceed.
Okay. Masidiso, because I was out of my presentation. You can see my slide, right? It's talking about.
Yes, we can see your slides. Yes.
Okay. The fourth form of intellectual property that we're going to talk about today is the plant breeders' right. So this form of rights is one that is not administered by the CIPC for obvious reasons. So this is administered by the Department of Agriculture because it has to do with food at the end of the day that people are going to consume. So it's quite important that it meet all the minimum requirements and no one is danger from the varieties that might have mutations on their genes that can affect people. So what is this plant breeders' rights about? It's about plant new variety. So we refer to them as breeds. So this is the combination of various things. So the breeder will say, okay, we need to have, for example, oranges that are more sweeter or have got more water, and then they will take from the two that they have, and then they will do the breeding so that they come up with a new variety. So example of how you get the seedless grapes in the market, so that will be a new plant variety, because under normal circumstances the plants do not the grapes doesn't come without seed. So it's about the combination of the various fruits or vegetable that they come up with. So one need to complete the forms and all the technical questions for applying for the plant breeders' rights with the Department of Agriculture. And depending on what breed do you want to come up with, if it's within vines and tree, you get 25 years protection, and other cases you get 20 years protection. The requirements are very, very strict. You need to make sure and demonstrate that what you are coming up with is new. So you can be able to see the difference between the two that have come up with a new variety. It's distinct, so you can be able to distinguish when you put the three there that they are not the same, with the two new ones, that the parent one that they come up from. You need to also be able to demonstrate after growing it for some time that they grow uniformly. So one is not growing as a dwarf and the other one is growing as a giant, because that sort of raised alarm to say, are they the same thing? Is there no mutations that might be happening? That's why they're not growing uniformly. And also that it's stable over various planting period. They grow the same. They are stable. So that's what Plant Breeders' Rights it's about. The people who might be affiliated with the Agriculture Research Council might be much familiar with the Plant Breeders' Rights, because they are the ones who in the country who does a lot of plant breeders, the new plant varieties. So this is just a typical example that you can see that this is the various leaf mustard. So it's the same thing, but you get various varieties. So the other one will be a new variety that one can ask protection for. I'm sure you have experience for those who eat avocados. You get different avocados in terms of texture, taste, etc. So those are the various variety that the breeders actually come up with, depending on what is it that they want to achieve. They want to have much creamier avocados. They want them to be bigger, more watery, not too sweet. So that is all about plant breeders' rights. It has to do with new plant varieties that are coming into the market. So that's just two examples of the plant breeders' rights. And this can take a long time, because you need to be able to meet those stringent requirements that I've talked about. The minimum requirements is very, very important to always remember that one need to meet them. The fifth one that I'll talk to today is the patents. I left it a bit at the end because they've got quite a bit of information, and I know most people knows about patents application compared to other forms of intellectual property. So normally there's three also minimum requirements that one needs to make sure that you meet. So I'll talk on this next slide, but you need to make sure that you're coming up with something that is absolutely new, it is inventive, and it have got an industrial use. You can protect for method and processes of doing something, which protect the underlying technical concept of an invention. It also gives you an exclusive right. So we always refer to it as it confers negative rights. So it gives the holder rights to prevent others from making, using, or selling the invention without the permission. However, the owner of the patents may decide to grant either a license or give an assignment for the invention that they've come up with. I know I'm talking to people in the space where most of you, if not all of you, have written an article or at least have read an article. So the patent specification that is being referred here, in your mind, just think about an article. So you need to provide all the details in terms of how this thing actually work. And I know in practice, normally scientists, they will write what this invention does in a format of an article if they are liaising with their patent attorneys or their offices of technology transfer within the higher education institution and science council. We'll talk briefly about that when I talk about the IPR Act. And what you get is 20 years protection from the date of first filing. So we're not able to prove first to invent, which in other countries used to be the case, but as long as you are the first one to file. Let's say I'm working on a research on enzyme that I want to use during winemaking. If I file today at the CIP office on the 25th, and someone happened to be working on the same subject matter in the USA, when those rights are granted, they will be granted to the person who actually have filed first. So that date that you file is very important. We call it the earliest priority date. So that's the person who have actually filed first, with the assumption that then they've been working on it first, unless you have stole someone's innovation and someone can prove that actually they took it from me when we were trying to establish a collaboration, etc., etc. Like I've already said, you need to pay your renewal fee for you to be able to continue to have your patent rights. If you don't pay renewal fee, it lapses and the patent doesn't exist. And you can only enforce it once your rights have been granted. So you start all these filing as an application. You don't have rights to enforce during application phase. You only have rights once it has been granted by the administering office. However, let's say, for example, sometimes it takes quite long. South Africa, we're looking at about 2 to 3 years because we don't examine. But in another country, getting a granted patent takes very long. So you might be able to say on year 4, you see someone is doing similar what you're doing. You can just inform them or send them a courtesy letter to say, we understand that you're working on something similar to what we're working on. We have filed for application on this. Can you please stop? But you cannot then give them boldly to say they must stop before you are granted those rights to do such. But you can say, we have applied for this, we're in the process, we are infringing on what we're doing, can you please stop? If they don't, then it means you must wait until you've got the granted rights to be able to enforce your rights. So these 3 requirements are quite crucial for patentability for patents. You need to make sure that it's new. You must not disclose your inventions. A typical example that researchers does is that they'll go to a conference and present about something and then realize its potential later than they want to have a patent protection. That's why we always advise for people who are based within institution, you must check with the offices within your institution that deal with intellectual property to tell them, I want to go to a conference, but I've got this that I think I've got potential that I'm working on, so that they can advise you accordingly. I've seen in practice where provisional patent application are filed within a day or 2 so that a person can be able to actually go and present without destroying your own novelty. Because in patents, even if you are the owner of that invention that you come up with, and someone can pick it up when they do the search through that presentation in Barcelona, for example, you will actually destroy your own novelty. So that will be regarded as a prior art. Because I always get this question, can I destroy my own novelty? Yes, you can, as long as it's out there. There's a prior art, even if you are the one who have actually presented and you are the owner of what you intend to file. It needs to be inventive. By inventive test, we're referring to for the people who are skilled in that particular field. Is this so obvious compared to what is already out there in the market? This is not a question that anyone can answer. It's only the people skilled in the art. For example, if you are a chemical engineer, for chemical engineers, is this thing so obvious that from the one that is already out in the market, I can just skip one step and come up with something that I claim to be new? So that is the test that get carried out there in terms of inventiveness. It's only for the people in that particular field. Industrial applicability, almost anything and everything have got use. So if you can just be able to demonstrate that it can be actually be used. That requirement, the last one, is quite easy to actually meet. So in South Africa, the Patents Act exclude certain things you cannot patent, things like discovery, theories, mathematical method, all your works, because already they're already protected by copyright, way of doing business, playing a game in South Africa. You cannot protect that through a patent. A program of a computer, that can be protected by copyright as well. However, sometimes you find the technical effects actually can be protected by a patent. This is where the expertise and the skills of a patent attorney is quite important, because they're able to actually guide you in the right direction. So two particular example, I'm sure you have known of the Shazam. So a song is playing, you're able to check which song is that by just doing the compatibility of the lyrics. That have got patents, even though if we might think that maybe it's a program of a computer. So it means that it will have made that its technical effects could have been something that could be protected. Also, presentation of information in South Africa is not able to be protected. In South Africa, there's or not in South Africa, but throughout the world, there's a lot of there's a process, and I think in some instances, some forms of intellectual property is quite straightforward in terms of how you go about filing. But in patents, I know there's quite an interest of saying you can file for your provisional patent application, so you got your earliest priority date, and that allows you to say in 12 months, you can then file for a complete application in South Africa. So it gives you that 12 months to further work on what you have and to determine, do I want to continue with this? Does this really have prospect? So you can continue with the complete application, and then that will be subsequently be granted in South Africa, depending if you're filling the forms correctly. So that's why I was referring to say we've got a formal processes. So as long as the forms and the right documents have been signed, we don't examine the specification yet in South Africa to say, is this thing indeed new? However, if you want protection in other countries that does examination, like your Europe, your US does examination, it's always advisable to say at that 12 months, you then file what we call the PCT application. PCT stands for Patent Cooperation Treaty. So this is a group of countries that have agreed on certain laws that govern them to say, we are allowed to file in this country, file one application and designate multiple countries for one application. So there's about 158 member states of PCT. I think there's about few countries that are not member state, like I know Venezuela was not part of it, and Argentina. So that means that, so if you're going to go the route of PCT, you must always remember that at 12 months, they're not part of the PCT application. Then you need to file individually to that particular country. So what PCT, the nice thing about PCT, what does is that it gives you an opportunity to do one application for multiple countries. I know it's still expensive. Protecting IPs, it is expensive. You might have to pay over 100,000 depending on the subject matter of your invention, but filing a PCT also give you a longer time to further assess your invention, but you also get what we call ISR, which is the International Search Report, and also an opinion on your invention. So that's examination. So it will tell you whether your claims of what you intend to of your invention are new, the inventiveness, and is their use. So at this stage, you can then decide from the report if you want to then pursue and enter various national phase, because once you start entering various national phase in different countries, the cost for protection just become more. So most people, after provisional, if they've got multiple countries that they need protection on, let's say 5 or 6 or 4, and it's mostly European and the US, because it's quite expensive anyway to get protection there, they'll go via what we call the PCT application route. And then once they get a good ISR and an opinion on their application, then they'll enter various phase, national phase in the US. In Europe, you can even get a granted patent, but you just need to then validate in the various European countries that you need protection on. So that's just basically an overview on how the patenting process can work. And it's quite easy once you get a positive PCT report to be assured that, or at least to be confident that you will then get granted patents in the other country that does examination, because this also it's examined. So that's why most people take the PCT route. So all that what I was explaining is just here in words in terms of how many member states are there and how to go about getting into other national phase countries. This is just an example of how a patent specification look. It's pretty much like an article, first page, maybe with more information. It will tell you in which country is this patent granted, to give you the publication number. It will also give you if this is a granted patent. Normally with the US and Europe, you see by having a B2. If it's A1, it means it's still an application. When was the date? Who are the people, the inventors? And this is quite important. The inventor remain inventor. Even if you work for a higher education or science council, your name will appear there. An inventor will never be the institution. However, like this typical example, you will see that what I was trying to explain when there was a question of, I'm the one who's doing this work, why don't I own it? By virtue of your employment agreement and policy within the institution, then the institution become the assignee. So you assign that IP to the institution. And it gives you all the details about priority date, when was it first filed, which other related patents this particular one refer to. And to give you the details about the abstract, the drawing, and the claims. The claims is the most important thing because it defines the scope of what you've been granted. What is it that you have got protection for? So I've protected a cell phone that I've got that can play music, that also have got a camera, that I'm also able to record. So that will be what a claim encompasses. So it defines the scope of what you're seeking protection for. So this is the most important section, if I can put it that way, on the patent specification, because everyone is interested to say, what is it that is being protected here? What is the invention? What is the monopoly? What is the scope? What is it that I, as a competitor, for example, can do over and above for what you seek protection for? So some things to always remember is that it's always first person to file, so that priority date give you the pen on the pack. But it's always also advisable that, because there are requirements when you file also your provisional pen application, that it need to be fairly based. So you can't just give us something so broad that you want to claim anything and everything. You need to be able to say what is it that within that space that you intend to do. Otherwise, that would not be accepted, especially in countries that does examination. But also, you must also remember, whatever you put on your first application as a provisional pen application need to be fairly based, so that when you file your complete, you can still be protected, because you cannot add new stuff, new matter after a year, because there might be someone who have come up with or filed for that particular one. So it's a matter of balance to say you don't file too early when you're not quite sure what is it that you want protection on. But the rule is that whoever will get eventually is the one who will file first. One thing, there's no worldwide patent. I've heard these people saying they've got a worldwide patent. Sometimes they're referring to say they filed a PCT application. PCT application remain an application until you validate it in the various countries that you need, or not validate until you file in the national phase, in the national countries that you want protection for. I'm correcting that because validation only, it's more for the granted European countries, where they validate in the individual countries. The other thing one need to remember is that you need to also know where you want to have products or services in. So it's quite important, because that will also assist you in determining the importance of where then do you need protection in. The other thing which is important, don't just assume your invention is new. You can do a quick Google patent search just to see what is out there. Even a quick Google, when you've come up with something, you will see the amount of things that come. And that's what, if you're doing it through a law firm, they will ask you, do we have to do a priority search for you, a novelty search for you, so that we show that indeed there's nothing out there that looks like what you have. Unless you come up with something which is an improvement of something that already exists. And if you're not the owner of the first one, you might need to have permission or a license from the one who owned the first one, so that you're able to build up on those improvements. So you need to negotiate with them. The other thing, I think, what is very important for organization as well, patents are not a means to an end. So it is good to have patent application or protection, but we're moving to why do you have that? Are you going to be able to take this stuff, the goods or the services that you're coming up with, to the market? Does that help you to get collaborators or licensees, people who can take on your technology and further distribute it? Or make the products, depending on what rights you actually give to them. So sometimes you find that patents might not be priority for you, but someone who wants to further invest on other research and development or putting those products into the market, they might be interested to say, do you have patents that are granted? Because that sort of show an indication, especially if you file elsewhere where there's examination, to say, there's a great potential in this invention, for them to be able to take it forward. Especially private sector, they are in the business of also making money and profit. So for them, that is quite of interest. I've gone through the first 5, which are more, I've got a legislation that govern them in South Africa, and the next 2, we're just going to touch base on the confidential information, the know-how, and the trade secret. So normally the words are used interchangeably, but in essence, confidential information is just information which the company have keep it to themselves. It's confidential to the organization. Know-how will be more in particular to say that organization the people who work in that particular project are the ones who knows how to do this thing quicker and better without having to have disclosed it elsewhere. However, when we start broadening into the trade secret, it's more where there's more a commercial value associated with whatever that the organization have kept to themselves. I'm sure you have heard, or typical example, your Coca-Cola recipe, that it has been kept as a trade secret over many, many years. Your KFC spices as well. That's why also when you have got a franchise for KFC, it will come already mixed, and the people at the various branches will just code the meat. They will never know how much of flour to put in there. So that's basically what the trade secret is. Seems to be working for certain organizations, but it's quite dangerous because once that secret is out, you are not able to enforce it because you don't have the legal rights. But if it's working, then you're able to keep that for as long as it can be kept a secret. What can be put as a secret? There's no limitation. It's either your data, your customers, your drawings, your specification. That can all be also kept as a trade secret. So you can put as much information as possible. Your business plans can be kept as a trade secret as well, for you and your organization. I think this last presentation, similar to the first one, it's nice if we having this physical. Normally we'll just send in paper to say how many form of intellectual property are you able to identify. For example, on the example that we did of the barber shop, you could see that there's various form of intellectual property in just one room. You can also get various form of intellectual property in just one product. For example, the Coca-Cola, that is a trademark, the logo and the way Coca-Cola is written. Trade secret could be the recipe, the actual drink itself, and that if they had decided to disclose, you can also protect that method via a patent, which in this case, in this example, is not the case. Design of the bottle. I'm sure you have seen that you also walk into a store and you're looking for deodorant or roll-on, and you get so many shapes and forms. So same goods, but just how the design of the container might be what attracts you to buying. It's easy to use. It's not too bulky on the hand. It have got finger groove for you to be able to hold it nicely and apply. Copyright, just on how to make the actual liquid. That details that goes into the book. So you can get a various form of intellectual property in just one product that you're looking at. I think that's all regarding the patent. And Matshidiso, okay, I just saw the time is 20 past. Maybe let's take question relating to this as we've agreed, and then we can then take a 10 minutes break, and then we can then come back and continue.
Thank you very much, Ms. Ntekenezeni. I don't know if we do have questions from the floor, and I'll check through our Q&A box as well. There was a question from Kenneth. After the patent has lapsed, do we get benefits if other people use it afterwards?
No. After the 20 years, it doesn't belong to you anymore, even if you were the owner of that particular patent. So you cannot get benefits. So that's why in that 20 years, you're encouraged to maximize as much as you can, put products on the market, give licenses to other people so that you can be able to charge them royalties for using your invention. But after 20 years, that's it. With the understanding that you should have made enough money. Now it's free for all.
Okay, and then there was another question from Poppy, but this one relates to IP. With the developed product through a collaboration, how does one go about IP registration?
Okay. There's not really one size fits all, but I'm gonna answer it from the point of view where you pretty much based at the research council or an institution, right? Because that's what I'm mostly familiar with. So when you are working on a project, if you are both creating intellectual property, right? Both of you are actually contributing towards intellectual property, you can own together. Even institution, we get a lot of case of work that get reported to us. It's a collaboration between CSIR and University of Pretoria, for example, because I'm based here in Pretoria. I'm based here at the CSIR, so that's what always come quick to mind. So you can co-own that intellectual property as the two institutions. We just need to always make sure that the rules of inventors, who's creating, is quite important. And I know this at universities come into play where a person is not contributing intellectually cannot be listed as an inventor. There is no what you do in articles where you list them according to the importance of contributors. In terms of IP law, it's only the people who are intellectually contributing that their names need to appear there. But if all of you are intellectually contributing, yes, you can co-own the intellectual property. Even the IPR Act, which is the legislation that we enforce, allow for co-ownership of intellectual property amongst the IP owners.
Okay, there was another question from Sidwell. Again, if I develop computer applications using my own resources and licenses during my personal time, but these applications align well with my profession and could significantly enhance work efficiency in my specific field, then who owns that IP? Is it me or the employer? I think you had touched on this before, but over to you.
Yeah, when I start seeing it aligns very well, I think we're just bordering on really still talks to your work. I gave a typical example. It should be able to be so far apart that you don't need a genius to distinguish that this is not what you're hired to do. I'm hired as a cleaner at NIPMO. I come up with an app. That's quite obvious that I'm not hired to do that. And I know when we do this awareness at institution, researchers sometimes they think it's not really aligned. And there've been case law where when we need to prove cost and scope, is it cost of your employment 8 to 4, Monday to Friday, or is that period where you are employed by, I'm employed by the DSTI? Is that just that whole employment, which includes Saturday, which sometimes I think about work when, because I'm one person, right? I can't cut and say this is between 8 and 4. So I think there's a fine line there, but the person who's coming with that, normally they will know if really this is within what they are hired to do. But the test, because if you're disputing that, your employer might have to get legal people to look at it and then might have to go to court. In your mind, it should be quite clear that it's easy to distinguish that this was not within the course and scope of my employment. If you feel strongly that it's not, and you might want to engage your employer to say they might not be interested, it's a different negotiation altogether. But when I heard the last bit up, so it can contribute to how efficiently we do the current work, which I'm thinking could be very close to what you're hired to do. That's just my thinking. But it's one of those where there's no right and wrong answer. But what I always say is you should be able to fairly distinguish if this I was hired to do or not.
Thank you very much. There was another question from Cyril. Is it worth registering an IP with all the commercial aspects related to chasing someone in the world who has broken the IP in another country? And if you keep the IP secret as a trade secret, in preference to detailing your innovation in the IP registration, which could be reverse engineered and cost you large amounts of money to control the IP, the costs seem to be excessive to try and have IP registration, even if you're making millions on the technology. I think that was a comment from Cyril. Any thoughts on that?
Yeah, it's indeed it's one of those things that you need to know as an organization what your IP strategy and commercialization is going to be. Like I just gave a typical example of a big organization. They run a risk, they're keeping it as a trade secret, but also they don't run a risk if no one ever disclose, but they also run a risk if someone ever have to disclose, so everyone will know about it and they can't enforce the right. So their competitors will also be able to make it exactly how, for example, a Coca-Cola tastes if you drink a Coca-Cola and a Pepsi. I like to give that example. You just feel like there's one or two ingredients that is missing, to give you that satisfaction that you get after drinking Coca-Cola. So it is it depends on your mission and what you want to intend to do as an organization. And from the examples, all of them can work. But the challenge is if you want to have other people as collaborators that might be interested to see how strong your IP is, you might not be able to do it as a trade secret because you don't want to disclose it to them. But if it's something that you think you can run with it on yourself, on your own, you can then just keep it as a trade secret. But if you still need other funders to pour into your money, or you want to license it to someone else, or you want to later on to say you sell the whole IP portfolio, protection might come in play. And I understand very well it doesn't come cheap. It is expensive.
Indeed. Thank you very much. I'll now open the floor for 2 questions. If anyone wants to pose a question or a comment for Ms. Ntangane Zeni, you are more than welcome to do so. We'll just request you to put up your hands and we will allow you to come through. Thank you very much. Is there any question or comment from the floor? Before we break for about 10 minutes. Madeleine, if you can just help me identify if there's any hands from the floor.
I don't see hands.
I don't see any hands. So colleagues, we will then break for 10 minutes. Okay, there was another hand. You can come through, Albina. Madeleine, if you can allow Albina to come through. You can unmute and come through.
She is permitted to talk. She must just unmute on her side.
Okay. Albina, if you can just unmute from your side, then you can come through with your question or comment.
Perhaps it was an accidental hand. She is unmuted. She can talk. I see Kelly and Peter is also raising hands now. I'll also unmute them.
Okay.
Kelly, you're able to
Petro, you can come through. You are unmute now. Petro Erasmus.
Yes, good morning. Thank you very much. This is very informative. My comment is actually just, I would like the attendees to take note of your slide here and how you've referenced the IP strategy, that diagram there. And I just think that as EAPS, that is something where we sometimes miss the boat completely, is that our referencing is not correct. To ensure that we comply and give credit to this IP, intellectual property. And yeah, I just wanted to raise this as something that the EAP should take note of on how to do that.
Thank you very much, Petra, for that comment. Albina, do you perhaps want to come through? While we're waiting, Dangenezeni, do you have anything to add?
Nothing to add from my side.
Okay. Thank you very much. I think we can break for the next 10 minutes. If I can request that we come back at 11:40, let's say 11:45 actually, then we can proceed. Thank you very much. We'll see you at 11:45. Welcome back to all our participants. Ms. Ntangenezeni, are you here so that we can proceed with the presentation? If I can kindly ask you to unmute, then we can proceed. Thank you very much.
Thank you, Matsidiso. You can see my presentation, right?
Yes, we can see it.
Okay, all right. I'm going to proceed so we can continue. I think the next few slides, we're just going to talk about some of the IP strategies and IP policies so that you're quite cognizant with what is available within the institution. So I think it is important that an organization itself have got the strategy. The strategy could be internal strategy when it comes to IP matters, and how that will be developed, and how once it's identified, how will it be managed. So one of the things that you can do internally is to have an IP policy that everyone is aware of, just to avoid not knowing what to do when you've come up something of value, or who's gonna own, etc., etc. For external strategies that one can have as well, could be things to say, how are we going to use this IP as an organization? It's not good enough that we've come up with these brilliant ideas, we have protected them, but then what are we going to do with it? Which will come on the slides that follow later on. How do we then use these assets that we have as a tool to engage the third parties that might be interested, and also how do we position ourselves with respect to the competitors out there that are doing similar or in the same space with us as an organization. So this is just some pointers in terms of saying why it's important for an organization to have IP policies, which I can add this for all the higher educations and what we refer to the Schedule 1 institution, which mostly are your science councils, have got IP policies, and they need to submit to us for approval to see if we approve certain clauses if they are compliant with the legislation that we have. It is important because it provides structure. It also make employees at ease in terms of what to do when. It also create industry-based practices in IP management. It also, in many instances, able to talk to how IP will be managed, and also in certain instances where employers have got some benefits towards people who are prolific inventors or innovators. What is it that they get out of it? That could be helpful, because I know in higher education and science council, there's always an issue in terms of saying, but people who publish their papers, they get more money than people who are just innovators. And I know that the Department of Higher Education, we work closely with them. They have started giving incentives towards people who are in the innovation space, to give them some points with regards to the inventions that they come up with. So things are moving. It's not only people who publish their papers that get rewarded. And I always say this, it's just a timing thing. You can still publish your papers and still protect the innovations that you come up with. So that's why it's very, very important to have your IP policies. What is it that one try to get as a goal for IP policies? provide that institutional framework. It also, promote and encourages research and development. It must also talk to consideration in terms of commercialization opportunity that the organization want to take or follow. It will talk about also, it's just to encourage of it foster IP awareness. Also make sure that people comply with the relevant legislation that regulate the space they are in. And also, if there's any rewards that the employer give towards the innovators, the employees also know about it. So those are some of the goals for IP, having IP policies in place. There are certain things that one maybe as an employer can take into consideration. I'm not going to dwell into that because I think it's more researchers that are in here, but there might be people who are influential, who are in policy development, that could take some of these important things. One must just also look at what is it that we want to achieve as an organization, define the scope of the policy, have terminology, explain them, what kind of intellectual property does our organization mostly focus on, and how we're going to manage this intellectual property once this someone come up with. What are the responsibility for the researchers once they come up with something? They need to be able to disclose. That IP need to be assessed, protected, and commercialized where it is relevant. And also how we're going to share these commercialization outcomes, if any. Some of these things are the things that the policies that institution have actually talks to. For in case where there's dispute or conflict of interest, how does one deal with it in the project that they're working on? So this is where in you like the other previous question that I'm in the space, but I'm not really in the space. Something that I think it can enhance. If you've got something like that, how do you probably go about? But if I also continue to go work on it, and this is something that my employer is disputing, some policy will then say, how do we go about resolving that? Do we get a mediator to listen to our story and then decide? So those are some of the things that one need to put into consideration when developing the IP policy. So I have been referring to this as I was going through the presentation so that it sort of makes sense, or it sort of links that when you're working on these innovations or these technologies, one need to also think about their IP protection strategy, which will then also talk to their commercialization or the utilization of that intellectual property. One need to know, in terms of territory, in which country do I really want to sell, or where will I be making these products that I'm coming up with? Who are the potential people in the space that if I don't want to do it myself, I can license the technology too. So those are the licenses. If I want to go into a particular country and get a protection, how strong is the legal system that I'm able to defend my rights if I have to take someone to court who have infringed on the protection that I have? This was one of the questions that, or more a comment on the previous before we break. Can what I'm sort of investing that I'll be able to get out of commercializing this intellectual property vis-a-vis the amount of money that I've spent, does it justify the protection cost that I've incurred before I could put this stuff in the market? So those are some of the things that one need to think about as they're coming up with their IP protection strategy. The other thing is one need to also think about competition. When you come up with invention and they want to put it out there in the market, one must also think about, am I entering into a space where it's so saturated that there's so many people doing the same thing? Are there similar products or technologies out there? What are the benefits on those ones versus mine that I'm coming up with? And those that are there, how widely are they used? Do you see people having interest on them? Do I think that there's a gap in the market that I need to address? Because we must also always remember that technology is meant for a specific uses. For example, a person who have come up with, and I hope no one is gonna ask this question. Maybe I might be opening a can of worms, but we'll deal with it when we do question and answers. As someone who came up with please call me, right? As a way of addressing a challenge that people who don't have airtime can always send a please call me, was targeting a specific market, right? Or a niche, or they saw a gap there. But that technology is not meant for everyone. Someone with a contract phone and money is not really a problem to make a phone call. They don't think it's such a great invention, for example, you know. But if you are a high school or tertiary institution, you stay far from your parents or your guardian, that's a very cool innovation, and you've got people in your space that you know they can always give you a call back, because then you don't have to worry about having airtime all the time. I'm just giving that as an example. Someone who have never flew, you know, they are not in a space to think about aeroplanes, like someone who frequently fly, who start to process, sure, took me 11 hours to get to London, how many kilometers later? So what I'm trying to say is that technologies and innovation are just market orientated and target a certain group. There are technology that you think it's very small, but the people who have come up with those, they're actually making good money because there is market for it and there was a need for it, and they're closing up a gap. I'm sure all of us will also agree with things like we have had meter taxis in South Africa for so many years, but just how expensive and how use for it compared to now an app which is Uber in this day and time of technology that is not going to charge because of the number of people, just going to charge for the trip. So those are some of the examples that I'm just bringing up here to say it's what can assist in thinking about who are your competitors, what is the gap in the market that I want to address, and who are the main competitors and how big are they? Are there also potential people that I can collaborate with or license my technology to? Is it one of those markets that have got dominated by only a few players? Will I be able to crack into that market as just an individual? And what is the competitive advantage of what I'm bringing to the market? There are some technologies that are out there, but you find that you don't just have a market for it. Maybe it's too expensive for the people in that particular country, so you're not able to really break barriers in the market. These are some of the way one can actually use the intellectual property that they've come up with. You can exploit it yourself as the person who've come up with it, incorporate it into your product and market it and sell it yourself. Or you can then look for people to license that technology to, who then pay you money for using the technology. A lot of people do these licenses. Sometimes also you find that a person, I've developed it to a certain level, institution and developed it to a certain level, but I need further money to do research and development. You find that some people in the space, they might want to put in more money and then you can give them a license as well. Or I've developed it and I think it works, but I just don't have interest or further to pursue it. Then you can sell that IP or assign it to someone else who have shown interest. Within university setup as well, find that they've come up with technologies and it's working well, but you find that because of just how the system work of an organization, that technology is growing big, and it's getting momentum, that you think starting a company that is just going to drive that technology could be something that you can do. So you can start a company just dedicated on that, either products or services that you offering. So those are some of the possible ways to actually use the intellectual property that one come up with. I've talked about license. Just thought I must just touch base. There's various form of intellectual property. So, of licenses. So you can give license, which we refer to as exclusive license, where you give it to only one party and excluding yourself. And you can also get what's a non-exclusive license. You can give that license to multiple parties who want to exploit. Maybe I can give a license to manufacture or make or distribute in various territories to different companies. So you give to more than one party. Or it could be a sole license. So where you exclude everyone else, but you can include the person who actually owns that particular one, that particular invention. So that's basically the forms of licenses that one can give to various people to further explore their intellectual property. So that's why for organizations, it's quite important that you've got a strategy. You know how once this IP is developed, it's not going to sit on the shelf and no one is doing anything about it. If it makes money for the organization, you're able to drive your products and services, it's even better for the organization as it is. Matsidi, so I think I'm gonna proceed because we just came back now and finish up the presentation, and then we can then take question and answers after that, because this one is not quite a lot. I'll be able to go through them a bit very fast, because I just want to give an overview what we do as an office.
That is duly noted. Yes,
okay.
We may proceed.
Okay, so like I've already said, I come from NIPMO, which is the National Intellectual Property Management Office. So we implement a legislation called Intellectual Property Rights, emanating from Publicly Financed Research and Development Act. It's quite a mouthful, but actually just describe exactly what we do. So when government have invested on research and development within our higher education and the science councils, they put money in there so that R&D can be done. This legislation regulates what happens or what needs to happen to the intellectual property that comes out, and subsequent that intellectual property need to be used or commercialized for the benefits of the people of South Africa. So this legislation came into being in 15 years ago. So came into being 2 August 2010. So it had 3 main pillars of what needed to happen. Was to establish our office so that we oversee what the Office of Technology Transfer offices are doing within institution. It was also there to make sure that we implement what the IP fund, what we refer to as the IP fund. So IP fund talks to the IP protection and maintenance costs. So what happened is that within universities and science council is that they spend money on protecting the intellectual property, and they can then claim up to 50% of what they have spent on protecting and maintaining the IP from NIPMO each and every year. So they spend first, and then now they can claim after a financial year. Also, the main thing was to make sure that we establish what we call OTTs, an Office of Technology Transfer. I'm sure if there are researchers who are based at universities, they know about these offices. Normally, they sit within the Department of Research. under the DVC of research and innovation, and sometimes an internalization. Yeah, so that's where normally this office operates from. It need to look after the whole departments and colleges within the universities, what they're busy working on their R&D and what IP is coming out of that, and then assist the researchers in commercializing that intellectual property. So I think the whole purpose for this legislation was to make sure that the IP that comes out, at least is being used, since government have put in some money. We're just not investing on R&D and protecting IP, and then there's nothing that happened to that intellectual property. The objective, it's also to ensure that human ingenuity and creativity must be acknowledged. So this talks to the people who come up with these new innovations. So the IP creators, it's of importance that universities have include in their IP policy and the science councils that how they're gonna actually encourage creativity within their spaces, and how they're gonna reward them in terms of giving them some benefits over and above what they get every month by virtue of being employed by them. And also one of the objectives was to make sure that qualifying small enterprise and BBB entities be given preferential access if they qualify and they are looking for a license from some of the bigger players that are funded by government, like your higher education and the science councils. So this slide here just show about how this legislation came about, derived from the Science and Technology White Paper. The legislation have got a very specific mandate, very specific scope. We only look at intellectual property that was created after 2 August 2010. Anything that was created before, the universities and science council can deal with it the best way they deem fit. So the legislation was not retrospective. Also, the other question that we ask is that, is there research and development that have been involved in creating that intellectual property? If there's no really R&D, then this legislation is not applicable. And was the IP created using public funds? If it's yes, then the IPR Act will then apply to that intellectual property. So all those questions need to be answered, and the actual legislation doesn't have a definition for what R&D is. We use the Frascati manual in terms of defining what R&D is. We have got 3 offices, just in a nutshell. It's regulatory and compliance. So we just look to ensure that the institutions and the Science Council comply with the legislation. When they must report the disclosures that get reported to them twice in a year. When they want to do certain IP transactions, they will need NIPMO approval. So in case they want to now sell the IP offshore, they will need NIPMO approval because government have invested money. So now why are you taking the IP elsewhere? So it's just a step to say someone is checking that money has been invested, but however now we don't want to further pursue. We can make money still for the inventors. Then we want to sell this particular IP. Also, IP policies that we need to review to make sure that they comply with the legislation, and just issuing guidelines really that talks to how we intend or how we interpret the legislation, how it need to be, how we interpret the legislation, so that we assist the universities in implementing the IPR Act properly. We also have got advisory and support, so they deal with just advocacy, educational and learning. So IP-wise, it's part of the initiative run by this directorate. There's quite a lot that they offer. They do the WIPO Summer School. There's a summer school every year towards the end of the year for 2 weeks where one can go and learn more about IP and commercialization. Unfortunately for this year, it is already closed in May. So normally we advertise and universities also advertise, run by one university this year. And last year it was at Mangosuthu University of Technology. And we get speakers from all over who come and talk about different matters on IP and commercialization. There's also what we call the Swiss commercialization workshop, and then we sometimes collaborate with the universities when they do their World IP Day, which is already a past because this year it happened on the 26th of April each and every year. We also get funds and incentives. They're responsible for IP fund, which I've talked about, which is to provide rebate to the institution on the IP and maintenance costs that have already incurred. And this, we also do the incentives for the IP creators through an award. NSTF, we've got an award for innovators that we get advertised, and then we give an award there for best innovation, SMA innovator. And DHEAD creative output, which I've spoken about, people in the innovation space who are based within higher education and science council are also now able to get points on the work that they've done. Yeah, so in essence, it's just about fund providing the rebate and also the various awards that we give. I think of importance here, I would like to highlight for people who are not normally, who might be looking for funding, they also have got something that we work with innovation CIPC called the Inventors Assistant Program. So here you can apply if you meet the requirements. Also for SME who are not able to do their protection, you can apply and get money towards protecting of your IP. But the CIPC have got their own criteria that they look for before they can award. But we work closely with them on that Inventors Assistance Program. There's few things that the legislation brought change into. At the beginning, there was no really, it was not prescribed who owned the intellectual property. IP ownership was not fully, institution will just decide to deal with IP ownership issues the way they deem fit. So the legislation came and then it changed that. I'll talk briefly about it on the next slide. Also, there were no one place where we can see all the invention disclosure that are coming from Higher Education and Science Council. And now we do, because they report to us twice in a year of the work that they're doing on the various areas and what form of IP they've protected. And also it brought this requirement that approval is needed if the person who used government money to do R&D and then all of a sudden want to give a royalty-free licenses, you need a NIPMO approval to that for that, because you're not getting any money into the institution. If you want to give offshore licenses, because you're giving away all your you're giving your rights someone out of the country, we need to know about it. Or also, if you want to sell completely all your rights, you also need, when you want to assign offshore IP, you also need NIPMO approval. And then also if you want to sell your IP locally, because it's not going to be in your names anymore, we also need to know when you do that. There also something called benefit sharing, where we make sure that the IP policies that the institution brought to us, they've got provisions how they're going to share the benefits if they start making money, how they're going to share with the people who came up with those brilliant ideas. And also the main thing was that we ensure that there's someone, our feet are on the ground at Higher Education and Science Councils by establishing of the OTTs. So previously, I think IP ownership it's quite important. So now the legislation mandate there's three possible ownership of IP scenarios. So a person who receive that money and do research and development will own that IP. For example, money get allocated to CSIR, for example, or one of the higher education university or vendor. They become the recipient of public funds. So they will own the intellectual property that comes out of there when they do research and development. It also provides for co-ownership of intellectual property. So if they collaborate with another party, CSIR and investor vendor collaborate together, and all of them are contributing resources, they are co-creating together, and they've got an agreement how they're going to take the stuff that they're working on into the market. They can own. We also have got ownership provisions wherein a private funder wants to fund research and development happening at the Higher Education and Science Council, and they don't want the IPR Act to be applicable. So we've got what we call full cost. So they must pay the whole amount of doing research and development at a public university or science council without government money being involved. So they then will pay everything that has to do with that project, and then the private funder together with the institution, they will negotiate how that intellectual property now need to be owned by who and how they're going to commercialize it. So those are the three ownership provisions that the legislation talk about. I think we have spoken about commercialization previously. People will just work on research and development and do the publication in scientific journal, and then they will not think about how else, to use this intellectual property or to commercialize it to make money for the institution. So that's another thing that the legislation actually encourages. I have already touched base on the fact that now we've got a database where institutions report to us what they are doing with the disclosures that they get from their researchers within institution. So they will report to us to say we're working on this project and this is how far we've done in terms of IP protection, or we find a licensee who is willing to take up this technology, and they report all that, what they're doing with the various disclosures that comes to them. And like I've already said, licenses that normally doesn't generate a higher education or science council any money, that doesn't have any revenue associated to them, they will need more approval, because if you're giving a license, it's not making money, and there were money that was invested to do research and development for that project, it means that the institution is more disadvantaged. So that's why we need that particular approval. Or if you decide to sell that IP completely, you don't want anything to do with it, you need to just give us reasons why, because money to do R&D was invested on that research and development. The other thing that the legislation brought about was state access to rights to IP. The government doesn't have intention to just walk into Higher Education and Science Council and take the IP. That's not what the whole idea is here. It's just in a state of emergency. For example, someone come up, all of us, I think we lived through the pandemic. Someone have got a vaccine for COVID-19, and they've done quickly research and they found that it exists. They don't hood on it. The government can just negotiate with them to see how much do we pay you, so that you're able to share it with everyone. So it's only on the state of emergency that the state will have rights, to negotiate to use IP that a particular institution will have. Those provisions were there already, though, previously on the Patents Act and the Design Act, but it was not in all forms of intellectual property. So it's not really a new thing that give a particular government during the state of emergency to have access to intellectual property. Benefit sharing institutions are mandated to have a benefit share provision to say, if really the institution work on this, protect, and then commercialize this intellectual property, from the money that institution receive, at least you need to share the minimum with the people who have come up with these technologies, like IP creators. So in terms of the legislation, the first 20%, the 20% from the first 1 million that the institution receive need to be shared with the IP creators, and thereafter, once they've deducted their expenses, then 30% that remain, then they need to share with their IP creators. And there are universities and science council who have got actually higher benefit sharing provisions for their IP creators than what is on the legislation. And for OTT to continue to do functions within institutions when it comes to matter revolving on intellectual property and commercialization. That's all that I just needed to talk about regarding what NIPMO does as an organization.
Thank you very much, Ms. Ntenganezeni. Indeed, this was very insightful for us in the room. The information you shared today has provided, a favorable foundation for understanding the role of IP in our spaces, particularly for our registered natural scientists. We'll now move into the Q&A session. And we would like to invite our participants to post their questions or comments in the chat, in the Q&A box, and to raise their hand if they'd like to perhaps speak to you directly. And just in addition, we're also pleased about the exciting initiatives that are offered by NIPMO that I believe that our natural scientists can actually take advantage of. You spoke about the NIPMO summer school that offers in-depth training on IP and technology transfer. You also highlighted the IP commercialization workshop for SMMEs, which is essentially aimed at empowering small businesses. So I'd like now to open the floor for any questions or comments. I see there is a hand before I go to the Q&A. There is a hand from Nokol Nwaba. Over to you. They will allow you to speak now. Madeleine, if you can just assist us there.
Who wants to unmute? Sorry, did they put up their hand?
Okay, they put down their hand. It's fine. I'll go to the Q&A box. There was a question from Albina. So what are the requirements for a ZA provisional versus a regular ZA patent application, specifically looking at the requirements and the associated costs?
Okay, then the provisional application requirement, I know it doesn't include claims. You can just narrate and explain how your technology works. And I'm not sure about the exact amount, but I think it's less than, I think the last time I checked, it was 570, I think, to file for a provisional patent application. But when we give advice, we always advise that, doing it through a pen attorney will be able to help you with protecting properly. And then your complete will then have to include the claims on the specification. So that's the huge difference between a provisional and complete application.
Okay, and there was another one from Mark, and this was in relation to declarations in reports to clients. And he said that the client owns the results which they pay for, which they pay you for, but you own the method to get the results. So essentially the client cannot just hand your report to competitors who can then copy your comment. I think it was linked to a question that he had posed, how to safeguard a proposal, or rather your IP, so that it is not just put out to tender by a potential client.
Yeah, I think there might be few issues there, and I'll not be able to give a definite advice on this. But I think it will be important to engage with your client to know what is it that from what they pay you, then they own. Because I'm trying to think out of the box. Have one narrated do they have to narrate to the T that methodology? Because sometimes you can still be able to explain something without giving the specific details. I know that in specification it's done. So sometimes also if a pen attendant is drafting and something that need to be put in a temperature, you'll find that the specification will talk about something like ranges, will not give you a definite temperature point, even though if the people who are working on it know, but it cannot be just a vague range to say 0 to 100, but you might find that it might say 40 to 60 or 40 to 50. So maybe it's something that he can look at in terms of saying what is it that is completely disclosing on that particular report, which he is of the view that it belongs to him. But the first call point will be to check what is it that they've contracted with the client that they're paying for and what is delivering on. And like I was saying, like a typical lawyer is that, and the best advice and a concrete advice you can get from your legal advisor. If you are based within institution, those services are actually available for free.
Okay, and then there was another question from Munyaradzi. Is South Africa affiliated with regional organizations such as the African Regional Intellectual Property Organization? And what are the advantages and perhaps disadvantages of being a member to such an organization? Do you perhaps have an answer for that one?
Munya, I'm gonna assume that maybe you're from Zimbabwe. Looking at the name, yeah. So we've got the SADC body, right? There's various bodies. So PCT is one body, right? But that is more on an international level that I've got so many members. We've got the Paris Convention. So Paris Convention also in IP talks to the fact that they allow, or they will take your first priority filing date as such in the other countries who are member of the Paris Convention, right? So the rules are the same. We've got the OAPI. The OAPI is the French-speaking countries in Africa. They've got their own body, which then you can just file in there as one application, similar to what I've explained to PCT. Then we've got the ARIPO. ARIPO is the one that is referring to Munya. The ARIPO, it's the SADC countries, and South Africa is not a member. And I'm not gonna get into politics because I'm also being recorded, but I think it's just more political or not being an agreement, if I understand the discussions there well. So South Africa is not a member of the ARIPO. There's a great advantage of being affiliated to all these treaties, because it actually makes your application easy. You don't have to then go file one application in 16 countries. You can just do the ARIPO application. So that is the advantages that associated with being affiliated to the member state. So if you want to file through the ARIPO, you just need to make sure that you also have filed an application in South Africa, since they are not a member state.
Thank you. And then there was another question from Cyril, that there are organizations in South Africa that chase musicians' IP to make sure that they get acknowledged and paid. But there is no such organizations that assist scientists when their IP is infringed. And then Cyril was asking, don't you think that there should be an organization that assists scientists protect their inventions similar to the copyright infringements that are for musicians?
I think it might be a little bit tricky, because I don't think there's many instances wherein scientists are on their own. If you're comparing it to really the musician, it's just different how we operate. Most scientists are linked to either a company, right? You're a researcher there at a private company, or you are a researcher there at the university or science council, which they do have those offices that assist, in advising the researchers. So I think my take will be it's slightly different, and I think for researchers based within institution, they do have assistance or advice that they can get from their Office of Technology Transfer. Because in most instances, unless you're a small SME and you do your own R&D, then maybe you might want that particular body. But private companies that also does research and development, they should be able to, pursue this also on their own, because they also get incentives also if they do R&D through R&D tax incentives that the DSTI also provide to them. So yeah, that would be my take or comment with regards to this question.
Okay, thank you very much. There was a question, this was from Anonymous. Can an unexamined ZA patent application be a basis of priority for a EP application?
I'm not sure when you say basis, but yes, in South Africa we don't examine, right? Everyone knows that. So that's why normally people who mean business in the IP space, they will not just go and file it. They will do it through lawyers who understand what need to be protected and the law, right? And make sure that they've done the novelty search first. They know this thing is new. If you just go individually, go and file, right? And you fill in the forms and you submit, yes, you get that priority date. But the trick is that when you then have to go to a PCT, where then they'll examine and give you such report, then they'll pick up prior art that you cannot be able to overcome. So you will eventually not be able to enter national phase in other countries. So the South African provisional application can be a basis of a European application, but the granting is a different question that we're asking. So you can use your priority date that you get from South Africa. The test that need to be looked at in terms of, is it new, is it inventive, is it applicable, that will be done in each and every country that you need protection in. So you might eventually not be able to get protection, even if you have got that priority date being the date you file a South African one. This example, this is a case you can Google as well, that will be able to answer this question. So there is a DABUS. So DBUS, it's right, that the inventor need to be a person. right? Like living person between me and you. So I was presenting to potential IP creators. It's a person. That's why I was saying, even if you are doing it for the institution, when they list in your specification, inventor will always be your name. They will then appear as an assignee. They will never appear as an inventor because they don't invent. They are legal body. So in the case of DBUS, what happened was that an AI was listed as an inventor, right? Because we're more a formal office, that patent will definitely go through, right? But in other countries where the same thing was filed, that never went through because the person listed is not a person, it's an AI. So that's just a typical example. So things that might go through an office that doesn't examine doesn't necessarily mean it affect the other countries because, like I said, patents are territorial. They still have to do their own thorough search.
Okay, thank you
that's-
very much. Do we have any questions or comments or other reflections from the floor? If you can kindly just put up your hands and we will allow you to come in and pose your questions or comments. We currently don't have any questions and comments. Colleagues, we have now reached the end of our webinar, and as we conclude today's webinar on IP and commercialization, we would like to sincerely thank you for your participation and engagement throughout the session. At some point, we had over 300 participants who were engaging in this informative talk. And we also extend our appreciation to NIPMO for delivering such a valuable and enlightening presentation. The expertise has helped us better understand how IP can be used as a tool, not just for protection, but for empowerment as well, transforming scientific knowledge into real-world solutions and impact. Specifically, we'd like to thank you, Ms. Ntakenezeni, for leading today's session with clarity, insight, and relevance. Your guidance has added a real value to our understanding of IP and its importance and role to our work as natural science professionals. We are truly grateful for your contribution. And we also look forward to future collaborations. We've already highlighted the exciting initiatives from NIPMO that we will definitely take advantage of. And before we officially close, a sincere thanks to everyone who's attending here today, our participants. Your presence and active engagement really reflects a strong commitment to professional development and lifelong learning and the advancement of scientific excellence in South Africa. By choosing to invest your time in sessions like these, you're not only strengthening your own knowledge, but also contributing to more informed and innovation-driven scientific community. Just a reminder that today's webinar, the recording will be made available on our website so that our colleagues or your acquaintances can revisit the material at any time for reference and reflection. And we also highlighted that the session is accredited for CPD points and the certificates will be issued once attendance has been verified. And if I can just ask Madeleine to post that link again for the certificates as well. And as always, we also encourage you to stay connected with SACNAS through our website for some of our upcoming events that we will share with our scientists for professional growth and engagement. thank you once again for your time and your ongoing commitment to scientific excellence. May we continue to innovate responsibly, collaborate generously, and lead with integrity in everything that we do. Until next time, stay well, stay inspired, and let's keep on moving science forward. Goodbye.
Thank you very much.
Thank you.